Dear colleagues, I suggest we start, because our practice shows that sometimes the time allotted for a roundtable is not always enough, or is always not enough. And in order not to wait for any longer, we'll start, and Viktor Naumov will arrive shortly. Let us set off the scene, and I'd like to introduce to you the participants of this roundtable. As all of our roundtables at this venue, this one is an international. There are both Russian and foreign experts represented today. Participating in the roundtable, we have Anton Sergo, who is the president of the Internet and Law legal firm. He is also a professor of IP. Matthias Spielkamp is taking part in this conference. He's a partner from a German company, iRights.lab. Next to me is, to the right, Douglas Ginsburg, Chief Judge, United States Court of Appeals for the District of Columbia. To the left, Michael Wirth, who is responsible for business development in Russia and CIS. He's from IBM, who's our key partner for Skolkovo. He's a good friend of ours. And we're expecting Viktor Naumov to arrive shortly. He's the managing partner of Denton St. Petersburg office. We have a very interesting name. It's called IP Iceberg for an IT Titanic. It's a mysterious name, and probably some time will be needed to really digest the name, the title, but I would like to explain that we're going to talk about IP rights in the IT sector, in the most general meaning of this word. This discussion is multifaceted. We'll be discussing things somewhere on the borderline of law, economy, policy, social sphere, and so on and so forth. People participating in this discussion are very diverse. Some of them represent purely the business side. We also have representatives of the court community. We have people coming from the media background, and we have practicing lawyers in the area of IP and digital environment. IP in the digital environment. In the beginning of this discussion, I would like to talk about some social aspects, which are quite intensely discussed in the recent times. And in the Russian Federation, this question has been given a new light and a new meaning. Today we witness certain changes, certain shifts in a fight between the so-called proponents of the free internet, that are sometimes called pirates, to some reason which is not very clear to me. And on the other hand are the right holders and the right owners. I will explain to our foreign guest that in Russia this kind of fight is being carried out for 10 years. The right holders say, oh, Viktor is here. Speak of the angel. Right holders say that you have to fight and you have to beat hard the pirates, you have to block their websites, you have to punish stringently those who produce and those who deliver illegal content. Nobody's talking about punishing users, thanks God, but still the tendency and the trend is like this. And the right holders really have this urge to do something with the pirates. Now we're talking about definitely large right holders. The ones who are otherwise related to cinema industry, because cinema industry seems to be in the lead in this fight against piracy, and in some other areas such as music, books and book publishers. These parties and these participants of the fight, these parties also want to join in this fight. And as the result of such a lengthy discussion, a new law has been introduced that some of the websites can be blocked if these sites pirate video films, movies. And there's already some practice of implementing this law, and Anton will tell about this. We're seeing a second stage of this fight already now. The musical majors and book publishers, they don't want to lag behind, and they want to show what they're made of, and the government hasn't yet identified its own position in this war, in this fight, because the number of IP objects in these areas is much bigger than in the movie industry, and still there's no particular understanding of how it's all going to work with the musical industry and with the book publishing industry and the publishing industry. The question is much more extensive than just a fight between the right holders and the pirates. There are also parties, there are also people, and there are also companies who serve as internet intermediaries, because like Google, like Yandex, like Yahoo, they're not doing anything as they believe, but just translate and transport the information and simplify the search, but they do not generate the information and the data as such in the World Wide Web. So another question is, how do we treat these guys and how do we treat these companies? Do we have to really treat them as pirates or as right holders? Because from one side they simplify the search, and that means that they are also to blame. They simplify the search of pirated products, or they're just manufacturing automated engines. They are not anyhow involved in the process, so you shouldn't really bother them and just let them live. And this is the kind of a discussion we would like to have today. Let me leeway gradually to the economy, because any kind of limitations, they might be seen as good things, and they might be a measure to protect the right holders. However, this is also subject to discussion, because very often we hear thoughts that blocking doesn't actually do anything, and the right holders will never earn any additional money from blockings. But there are some other concerns, and a number of experts are outspoken about this. If we are to introduce limitations into the internet, we will prevent this internet industry from developing, we will impede its development. And in Russia, the internet economy is developing very fast. I can tell you about our Skolkovo experience. We are dealing with 5 areas: IT, medicine, biomed, meaning energy, space, nuclear. Definitely, IT industry and IT cluster and IT sector is one of the most vivid sector in Skolkovo. That's where, in this cluster, in the IT cluster, we have the majority of participants and residents. That's where we also have the majority of our products that are already ready and success stories. And there's a great level of competition in the IT sector. Many Skolkovo residents and companies work in close cooperation with their Western partners. They manage to sell their products. They're well known in the world. And it might be that they're not very well known to us, and we might not even know everything about such companies. But some of the products which are used by large companies, not just by IBM, I'm not only talking about IBM, but some of the large companies, majors, are using technological solutions that's been produced by our residents and our participants. And in the IT cluster, we have a much better situation than in the energy cluster, and even better than in the medical cluster. So I believe that if some limitations are being introduced, then we will probably mess with the positive dynamics. So I was setting the scene. I want now Anton Surgo to take the floor and show us some facts and figures. And by presenting these facts and figures, he will tell us about the practice of implementing the anti-pirate law in Russia. Thank you very much. Can I have the pointer, please? Good afternoon, dear colleagues. I do understand that it's difficult to compete with lunch, meaning that good lunch is always something that makes everybody sleepy, so I will try to do otherwise, basically wake you up. And now I'd like to show you some of the pictures that show about the practice of implementing law number 187. This practice is interesting, is unique, is unusual. I'm not a proponent myself of the pirates. I'm not supporting either the pirates or the right holders. I just want to show you the sheer statistics. I just want to show you the sheer numbers, and probably these numbers will help the lawyers to really judge, make their judgments and find out some outcomes. I've tried to point this thing into several directions, but it still didn't work. Now, just let's have a look at the pictures here. The statistics is like this. For the last 5 months of the last year and for the first 5 months of this year is almost similar. What's interesting is that number of requests for the security of claims is very big, and the number of claims that are being filed is about half of that number. Please do call out the numbers. I am very sorry for that, yes. As for the requests to secure the claims, 157. And all in all, 78 claims have been filed based on those requests. Some of the claims are not yet filed because there's still time to complete some of the paperwork, but the statistics shows that not all of the right holders have this necessity to file claims. For the right holders, the most important thing is to file the security of claim, which allows to block the sites without going any further. And as opposed to any other laws, we can say that the cinema industry was expecting this law to come very actively, because in the first month we saw lots and lots of activity. A huge number of claims were filed during the first month after the law was introduced. That was covered in the media quite actively, and you probably know about that very well, so I don't believe it's necessary to dwell upon that in many details. Now, who were those claims filed against? Well, first to Russian domains, to Russian registering companies that register domain names and hosting providers. Today, the claims are filed against the owners of the domain and hosting providers. Very soon, there's been a whole range of claims filed against foreign defendants, 47, which is quite a big number. 46, sorry. And very often when a claim is filed against a foreign defendant, mainly and generally it will be a claim against a hosting provider. And if we have a look at how many claims have been filed against the providers, it's 39, meaning 50%. So we see there's a clear trend. Nobody's fighting against the pirates, against the violators, the perpetrators, but against somebody who is servicing the websites, the technicians, so to say. We see that there are some negative trends, and this negative trend started off just after the law was introduced. Now these trends are becoming more visible. The first problem that we can see in here is the problem of execution. How the rulings of the court are being executed against a foreign defendant. I don't know whether a right holder is interested really in execution, or filing a claim is more important for him or for her than the rulings and then the execution itself. And sometimes the claims are being filed against companies and against people who didn't do anything wrong. Or there are claims against former and ex-hosting providers. And there are some very interesting examples and cases. For example, imagine there's a movie that's been put on the internet. First, it was on one hosting provider, then it moved to the second one, then to the third. And then the right holder would file a claim against the first hosting provider. But when this case comes to the courts, it will already be, this movie movie will already stay at the fourth hosting provider, but still the court will decide against or for the first hosting provider. And this is the kind of statistics we have to deal with, and this is the kind of a situation we live in. I think there's a gap, a legal gap, because the legal acts are not functioning properly, and so on and so forth. There's some cases when a Russian license holder files a claim because at one of the torrent trackers or torrent sites that is located in Uvalu domain, the movie itself is staying in German service, but the site belongs to a company from the US. And a Russian license holder files a claim to the Moscow court against all these companies and against all these parties. And it is the Moscow court that has to decide against all those parties, and not other jurisdictions. And there are some other interesting examples. I've been participating in such debates from both sides, and there are some very interesting examples of legal practice that I think is exaggerated. The anti-piracy activity is becoming too exaggerated. For example, imagine one site and 12 series or links to those 12 series were hosted on this website. The right holder in case materials have only evidence enough to support the cause and the case that only 2 links have been found. So the court says you are claiming that the rights for 12 movies and series were violated, and you are showing the evidence only about 2. And the court says if the defendant has some evidence against this, then they can present it and we will review it. So it's a very interesting practice. It means that our court has introduced something new in this whole practice, in this whole procedure, because when such cases come to foreign arbitration courts, there are no such outcomes. Let's have a look at some other statistics. What kind of claims are satisfied and what amount of claims are satisfied? I can be wrong, definitely, but I'm using some open statistics from the Moscow City Court. And I will explain it here. 100% satisfaction rate when using the Anti-Piracy Law. All these examples that I was listing, the lack of rights, the claims against foreign license holders, and so on and so forth. All these examples and all these cases pass successfully through the Moscow City Court, which now becomes in the lead of this fight against the piracy. And you see that the statistics is quite good, 100%. The instance of appeal is located in the very same Moscow City Court, and as far as I'm aware, 100% satisfaction rate in there also exists, so 100% of all the rulings are being supported. So this is the situation we live in today. The problem that we have is not just boiling down to piracy, because piracy is much bigger than that, and it actually extends over the limits of the law number 187. By just whip and carrot, well, there's even no carrot, just the whip. It's not efficient. Well, using this whip and carrot system is not efficient, and any IT expert will tell us that the cost of registering domain is minimal. It costs 89 rubles to register a new domain. Hosting costs about 100 rubles per month. With such costs, a pirate is in a much more profitable position than the right holder. So the measures that this law has introduced cannot be called efficient. Yes, we're continuing this fight. There's some victories, there's some success stories, but they're still not enough to say about any particular concrete steps. We held a conference some time ago at the Russian Chamber of Commerce and Industry, and we met with the representatives of the musical industry, and I heard that they have the same problem. The whip method is used more often than the carrot method. The carrot is not even offered to the right holders, and the right holder cannot actually give out to the users some accessible, some comfortable, some easy to use, and some cost-efficient services that the end users would be happy about. Today, the users are ready to start paying for legal content, but they want to pay fair. But they still need a very good and a very efficient mechanism of regulation of this problem. You might remember there was a problem of piracy with compact discs. Pirates were providing a much more comfortable service for the end users, and that's why they became the leaders of this industry back in the past. Unfortunately, our current right holders are not doing anything to support and to improve the service they are rendering. Definitely. These right holders and the whole institute of right holders appeared back in the past when there still was no internet. And that is why these right holders are very often like mammoths. They're not very flexible and they cannot adjust quickly to the reality. Now, if the two parties can make steps to find some middle ground, then we will be able to see some success. And it's not the sanctions that will predefine whether we're successful or not, and whether more legal products or more legal content is going to be consumed. We see that the whip method is not efficient, and the Western experience, I think, partially proves this cause and proves this point.
So I believe we are at a watershed moment in this aspect. What happens next, revolution or evolution, depends on all of us. And I would like to finish with that optimistic note. Thank you. Thank you, Anton.
To Douglas, so you got some impression of of Russian landscape in this issue. So maybe could you share us American experience? What does American justice do to fight against piracy? Maybe does nothing.
Okay. Well, we have really very little experience to report, at least in terms of legal disputes. In 1998, the Congress passed the Digital Millennium Copyright Act. Prior to that, it was really very unclear what the rights situation was. But the act has been, I think, quite successful in the sense that it's very simple to comply, and it's produced only one reported court case because it's easy enough to avoid disputes. Basically, firms that provide access to the internet service providers, internet access providers, are not liable for damages if they have distributed infringing material, so long as they are acting as a passive conduit, like a cable company or a telephone company that's simply used by somebody at one end to transmit copyrighted material to one or to millions of people at the other end. So there are safe harbors available for these providers. And the one that's generally applicable to internet service providers is the passivity, that they've not actively mounted the content or altered the content or done anything really to provide the content other than be there, and that when notified that they are transmitting copyrighted material, that they take steps to stop that. To quote the statute, in order to qualify for a safe harbor, there are really 4 of them. I've mentioned only the passivity one. To qualify for a safe harbor, the provider must, quote, adopt and reasonably implement and inform subscribers and account holders of the service provider's system or network of a policy that provides for the termination in appropriate circumstances of subscribers and account holders of the service system who are repeat infringers. Okay. And then a court can grant injunctive relief in one of two forms. An order that restrains the internet service provider from providing access to the subscriber who's receiving or to the account holder that's sending, using the service to engage in the distribution of infringing material. An order that the ISP terminate the account of the subscriber or of the account holder that's listed in the order. And then the second provision is that the court can issue a restraining order telling the service provider that it may not provide access, that it must take reasonable steps specified in the order to block access to a specific online location outside the United States. Now, virtually everyone who's written about this is of the view that the court can grant injunctive relief. Let me put another way, that a court cannot grant injunctive relief to block infringing material if the internet service provider is not itself liable. Okay? So if it's not liable, and if it would not be liable in damages, you do not issue a restraining order either, because it simply complies. So there's been only one case under the Act that has tried to expand the scope of the remedy, and that's a case called Arista Records versus AT&T Broadband in 2002, shortly after the Act was passed, 4 years. That was in New York. And the plaintiffs there, Arista, tried to get an injunction to block a Chinese website called Listen Forever, without any allegation that the backbone operators, the internet service providers and the internet access company, had done anything illegal themselves. Only the Chinese company at the far end had done the infringing. The complaint was voluntarily withdrawn because what happened was that Listen Forever went offline on its own. I don't know whether as a result of their being sued or for other reasons. I don't think anyone really knows or cares. So by creating a structure that makes it very easy for companies to avoid liability by getting notification, acting in a reasonably prompt manner, we basically avoided building up a body of jurisprudence and avoided having costly disputes over this, at least thus far. There's very little else to say. I think I'm here because I happened to be walking down the street and I had a badge that said I was from the U.S. and got a hook around my neck that said, "Come in and tell us about what's happened in the U.S." So, I've done my duty.
Thank you, Douglas. So, my next question will be to Matthias. We in Russia found very easy way because for right holders it's quite complicated thing to find a real thief of intellectual property, and it is better to block the activity of a provider who provides the transportation, and that is why it looks so. But what is your opinion? How in fact, we should proceed with this? What is experience in Germany? How these restrictions can influence internet economy, and maybe you can propose how we should live further.
Well, I'll say right away that I don't have a proposal, but I'll tell you a little about the situation in Germany because I do think it might be enlightening in some respects. It was very interesting for me to hear some numbers and the situation here in Russia after the anti-piracy law was passed, and I'll tell you that in Germany the situation is much different, because similar to what is happening in the United States, we don't have a law or any legal requirements that basically make it possible to block websites, to force ISPs to block websites. Now, interestingly enough, there was a huge effort to introduce such a law in the past, under the past government. The then family minister in Germany, she introduced such a blocking law on the grounds of being able to block depictions of sexual exploitation of children, which is usually a very good cause because everyone agrees that this needs to be done, right? So it's very hard to criticize. And interestingly enough, though, there was a huge backlash against this law, especially driven by the so-called internet community, whatever that is. You know, it's very hard to define the internet community, but there was a mix of the Pirate Party, some human rights organizations, some organizations fighting for press freedom, and so on and so forth. So it was a big coalition fighting against this law, because the argument was, if you pass this law, it's like putting up a facade, like, you know, giving a stop sign or putting a stop sign in front of something that is still there, and if you know how to walk around it, it will be still there, right? So while the introduction of the law was being discussed, there were already people asking for this law, which wasn't even then in effect, being applied to copyright infringement as well. So there was the clear danger that a law that, you know, was proposed for an entirely different purpose would be used to block websites because of copyright infringement. The law was actually passed, but in a very strange move. It came into effect, but it was never used until a certain point in time when it was retracted. So I don't know whether that was a first in the German history, but the law that had actually passed into effect was never used effectively on purpose, that is, because it was so contested, and then in the end it was reversed. So the situation is similar to what Judge Ginsburg described right now in the United States. The ISPs are not liable, but there is this institution of notice and takedown, also very similar to what applies in the United States. So if there is infringing material on a site and the hoster is notified, I mean the host can be someone else than the internet service provider here. That's also something that makes it even more complicated, right? But if for example, the company that hosts the content is notified of that infringing content and they take it down, then they are not liable for it. If they don't take it down, then you can press charges, and then this goes before court. And I think what's interesting here, and what I'd like to hear more about from you, Judge Ginsburg, is about the effect that it has, because what is being debated at least in Germany to a very high extent is the privatization of law enforcement in that respect. Because the companies or the private citizens, they can be bloggers, for example, hosting the content, are pushed into the role of a judge who have to decide whether this is actually infringing content or not. Now, every one of you who knows a little about intellectual property will know how hard this sometimes is to decide. But if you don't take the stuff down, then in most cases, or in many cases, charges will be pressed, and then there's that comes with substantial risk. You have to go to court, you might lose in court. If you don't lose in court, you might have to cut a deal with the other party. So first of all, it will cost your time, it will certainly cost some money, and if you're unlucky, you know, it will result in a loss in court. So you might argue that's not a problem, because if you infringe copyright, then you should be liable for that. But it puts the entity hosting the content in the position of basically what needs to be done by law enforcement or a judge. I'd like to add one more thing to that, because there's also something that I hope will be interesting to people here. Igor, you said in your opening remarks, well, at least they are not punishing users, right? Well, in Germany, they are punishing users. How can that be? How can users be punished? Now, it's very hard to distinguish between users and pirates nowadays, isn't it? If you use a file sharing system, basically all current technologies use protocols that, while downloading, are also uploading parts of what is being downloaded. You know, it's a technology thing. You could have something that doesn't do that. You could have a technology, and of course these technologies exist, but what is in use is usually a technology that uploads while you're downloading. Now, uploading is clearly illegal in Germany, right? So what's happening is, with downloading, it's still a gray area because there's a private copy provision in Germany, so it's a lot more fuzzy there. But when it comes to uploading, it's clearly illegal. If it is, you know, copyrighted material, of course, that's the only thing I'm talking about right now. So what happens is that if you find someone uploading copyrighted material, you can send them a cease and desist letter. And a cease and desist letter, this institution in Germany, is quite a good thing, because what the system, or what the idea was, is that what you do is you keep these cases out of court. You know, if your rights are infringed upon, and it doesn't have to be copyright, it can be everything else. It doesn't apply only to copyright cases. If your rights are infringed on, you can go to a lawyer, have them send out the cease and desist letter. And in many cases, they do that when it's quite clear that there was some harm being done. So the other party can decide to comply and, for example, take down material or offer some other kind of compensation. What they always have to do is pay the legal fees of the lawyer, right? Now, this has developed into a business model in Germany of enormous magnitude. You wouldn't believe it. In 2010, the estimate was that there were 600,000 of such letters being sent out just in the year 2010, and other estimates say that about 4.3 million of all German internet users, so 6% of Germans altogether, have received such letters. And the amounts that we're talking about, the money that we're talking about, comes up to 500 million euros. So this is quite a substantial industry. Now, what usually happens is, if you don't know anything about this, right, and you don't consult with a lawyer, you probably will pay all the legal fees, right? And because of the high definition of the harm that's being done, this is the orientation for the legal fees. So it's not unusual that you have legal fees that come up to 800 or 1,200 euros, depending on how many, for example, music files you uploaded. If you don't know anything about that and don't consult a lawyer, you probably end up paying these 800 euros, right? If you do know a little bit about it and you do consult a lawyer, they'll always be able to renegotiate that, because the rights holders know, and the lawyers also know, that it's very hard to prove really effectively in the end that this infringement has taken place. There are many cases where people contested these claims and they won in court. So if you did infringe, you know, and you didn't know or you didn't know, it doesn't really matter. You have a lawyer, they renegotiate the fee, and you probably go out and pay 200 euros to the other party, and then the fees to your own lawyer. But many people don't, so you can be sure that there are a couple of 100 million euros each year of, let's call it, revenue in that market, right? So that seems to be a problem to many people in Germany. And of course, many lawyers see this as a misuse. And there were 2 attempts already of laws, the latest one coming to effect only a couple of months ago. The first one was completely ineffective. They were trying to put in a ceiling for the amount of fees that the lawyers could use, but there were so many so many provisions in the law that made it possible for the lawyers to argue that this case, their cease and desist letter, doesn't fall under this law, that they were still able to charge for higher fees. And there was this new law, and we still don't know what the outcome is. But the situation is no blocking of ISPs in Germany, but at the same time a high number of cases of going at private individuals, which in the end means, and this is my conclusion, that there is basically a general disrespect for the enforcement of IP now in the German population, because this is what it's usually identified with. It's the cease and desist letter misuse industry.
Well, Matthias has addressed a question specifically, so I wanted to respond before we get off track. First, you expressed some dismay in the tone of voice about the privatization of the law, which is not something that we get excited about in the US. It's the normal way we deal with competition law. 95 to 97% of all antitrust cases are private cases, not government cases. Some of them are probably close to half are follow-ons to government cases, but the others are private cases with no government precedent. We refer to that as a private attorney general function, so that the government agency isn't expected to be all-knowing and all-seeing and have all resources. It is useful to elicit the efforts of private individuals if they think there's a violation at their expense. One big difference, however, in the systems is that we don't have the loser pays rule for attorney's fees. And so this has elicited some substantial problem with frivolous actions brought, particularly class actions, in competition cases, because if they can get past the hurdle of certification as a class, they pose the huge potential expense for discovery and litigation, and so the defendant settles even non-meritorious cases. A number of precedents in our courts and have cut back on that substantially, but it's a problem, a function of class actions without a loser pays rule. But we have no experience, of which I'm aware, with bulk mailing of these threatening letters involving copyright. I'm very interested that you've described this, because bad ideas usually jump the ocean very quickly. So I'm expecting this when I get home. But what we do have is something very closely analogous, and it just started a few months ago. Companies will acquire a portfolio of patents, perhaps thousands of patents from a particular seller, a company that either sells them outright or licenses them for enforcement. And the purchaser of the patent, or the purchaser of the lessee of the patent rights, has in now a couple of instances sent letters to tens of thousands of people. The patent is, let us say, in a well, one example, the most notorious one, is a patent that is used very commonly, almost universally, when something is attached, a document is attached to an email message. And so instead of writing a letter and threatening litigation against software companies that write email programs, one company sent tens of thousands of letters to people who send emails saying, you are infringing my patent, send me $100 or I'm taking you to court. This was considered an outrage by everyone who ever heard of it, and the result was immediately that the New Hampshire Attorney General, where this occurred, said that he would treat it as a violation of the State Consumer Protection Act, and the New York Attorney General soon thereafter followed and said he would also seek legislation to make that clear. There would be no support for this proposition anywhere whatsoever. But it hasn't arisen with copyright.
If I may, one follow-up question to whether I understood this correctly. You referred to this example of competition cases that are dealt with privately, but they are, what are you referring to? One lawyer, one company's lawyer talking to another company's lawyer, or this being part of the justice system, for example, someone filing a court case? Because that's what I'm saying is not the case when you put the burden on the companies who need to decide whether to take down the content or not. I still see a difference there.
I'm glad you asked for the clarification. There are about 800 private antitrust cases filed every year. What we don't know is how many cases are not filed because the lawyer calls and says, we're thinking of suing you, let's talk. And I can only imagine that it's quite a bit.
I think we can now turn on to the second part of our discussion today. And I think we still need to do some explanation in here. The law that we have today was originally initiated by large right holders and title holders. And if we are to analyze the needs and demands of the right holders in general, we see that the majority of such right holders do not actually need the measures that the law puts forward. And in the majority of cases, the right holders are not even in a position to track down, to browse the internet, trying to find out whether their rights are being violated and infringed or not. Originally, the law was established, the law was passed for a particular group of people, but now it's transformed into a different form, into a different paradigm. The right holders are now suggesting to create and to establish a register of copyright, a copyright register. This is something really unusual, something unique that even comes into opposition with the ideology of copyright, because it doesn't really provide for any kind of registration apart from the patent right. But the right holders, copyright holders, say, and why are we worse than the patent, or than the others? We believe that this registration system is a good and decent one, and it allows to identify very clearly what's what, and it allows to facilitate various court proceedings and cases. So let's suggest the following. Let's put in place this registration possibility. And if this proposal is adopted and accepted, if it comes through, then there will be no borderline between the copyright and the patent right. And I think this fuzziness in the borderline is already there. So my question to Victor here, Victor Naumov, you might not be expecting it from me, but if you can try to answer it on the fly, I will be very glad. Have you thought about this? Have you ever noticed that there is some kind of a juxtaposition and a mix between one kind of right and the other kind of right? Have you ever heard about this idea? And if you heard about this idea, do you think that such kind of copyright register will be needed and useful? Igor, thank you very much for such a question. You are absolutely right. This topic is debated for about a year by the right holders, by the government, by various ministries and bodies, such as the Ministry of Culture, and the Internet community. In particular, the Russian Association of Electronic Communication is taking part in this discussion. But I'd like to note two things in here. First, we're definitely moving to a direction of making equal some of the objects of intellectual property. And this trend can be explained by a simple technological idea. There is a clear trend, a global trend, which looks like this. In certain situations, right holders have a wish to burden the companies with the necessity to track down infringers and the perpetrators, the companies that are not perpetrators themselves, but they facilitate the transportation and distribution of information. And this trend becomes clear and visible because the internet technologies are getting more and more advanced. Because previously such initiatives wouldn't bring any positive effect. Now, when it's very easy to create electronic copies of various objects of intellectual property, you can search similar objects or model objects or objects that are have many things in common with the original ones, so you can always claim that there is a registered copyright object or an object of copyright or neighboring right, a model of such an object. You can find it in the register, and then it's up to me to decide whom to punish and whom to not. This trend and this desire is understandable, and definitely any company which has a certain amount of intangible assets in its operations would want to protect its rights. So it's a technical aspect. And there's also a practical aspect. When one can ask a question whether the modern technologies allow effectively, without any pre-moderation, censoring, or whatever other mechanisms that exist in the world, to realize and implement this database of copyright objects, if you want to protect your rights. Imagine you have a small poem, just 4 lines. To compare it with a model, with some kind of an ideal object contained within the register will be very easy. But when this task is becoming, when this objective is becoming bigger, more complex, when the poem itself grows to 20 or more lines, then the situation is becoming more difficult. And we must always take into account that not always the right holders claim about their rights, or even not all of them have such kind of rights. And moreover, not always these rights will give you a monopoly to use and operate the object. For example, imagine you have phonograms from one side, right? And from the other side you have concert versions of these same musical pieces that serve as a separate object of copyright. So what do you do there? If you cut out phonograms from social networks, from hostings, and so on and so forth, you would still not be able to avoid cutting out and taking out all concert versions of the same musical piece. So to my mind, establishment of such a register is basically an additional instrument. An additional instrument to some of the programs and databases that exist today. I think it has the right for existence, but we must not have in the law that everybody has to go into this database and do the pre-moderation based on this database. And also, there must be an understanding. You can't prescribe an understanding in the law, but at least in the practice, there should be an understanding that if something finds its way to this database, it doesn't necessarily mean that everybody must consult with the database online 24/7. So I believe the model that was formed 15 years ago in the world is quite sustainable. There's identification, there's counter notice, there's some actions that are done by the venue itself, by the site, the service, and so on. Definitely. And there are such trends seen sometimes in different countries. The right holders are not okay with this construct. They want real legal mechanisms to be implemented. For example, digital prints or digital fingerprints to be implemented that would allow you to delete an object automatically without identifying it. Which way will we follow in the Russian Federation? It's hard to tell. I believe that we need to go in the footsteps of the general internet development. We know that recently there's a new law on bloggers have been introduced, the new law on posting information on the net, and there's some sub-norms that are being discussed today about the disclosure of information, personal, private information disclosure. There's a new vector, there's a new trend that's just appearing, and not everybody's thinking about this. As soon as private information will fully be available to the government in accordance with the procedures set by the government itself, then going to court with the venues, with the sites, and claiming against those sites will not be feasible anymore, because you will be able to get all the data yourself. You will be able to find anyone who is infringing or who is perpetrating. You know that as far as user-generated content is concerned, it is the sites, video hosting, search engines that serve as defendants in such cases. And one of the arguments that right holders are using for that is because we can't find our end users. Today, in the current conditions, in the conditions of a changing legislation, this trend might change. How fast it can happen, it's another question. Maybe my answer was not very short and precise, but still I tried to cover all the aspects of it. Well, thank you very much for giving this description. I now would like to move on and discuss the economy, the economic aspect. I think patenting of IT solution is something unusual for Russia, for the Russian system. I won't now go into details about that. Probably you can't patent your IT solutions if you do certain things, but the patent system generally is built in such a way that IT solutions are not patented. There's a completely different situation in the US, in the United States of America, where, well, to my mind at least, and we had a session this morning and I was trying to touch upon this topic during the session, but my colleagues from the energy sector said that everything is good and great, the patent system works well, there are no problems with that, and the American Patent Authority doesn't see any problems whatsoever. They say that they are operating and working like a Swiss clock. And now it's time to give the floor to Michael Wirt, who represents the IBM company. I will actually praise IBM, because IBM is a flagship, to my mind, in the area of intellectual property in IT. They're always given as an example. This company earns more than anybody else in the world on IP. Well, maybe I'm mistaken, but at least they are one of the leaders of licensing of IP. They generate IP not just to protect some of the solutions that they're using in their own business, but also they're patenting something that it sells later. It's a separate business division of IBM. Today the world is changing. My question will be multifaceted. First, we see a whole number of patents generated and registered in the US, and that what brings a lot of patent wars. This is my first sub-question. How does that influence IBM business? Does IBM feel this pressure? Can you cope with the pressure? Do you believe that this situation is good or bad? Do you think it's comfortable? This is the first part of the question. The second part of the question, in continuation to what I already said, today in this modern world, our IT companies say that we don't want to patent anything because it takes too long a time, because you have to pass through various expert reviews. IT solutions get old very fast, so we don't really need it. Let's do it this way, and we won't even want to find out are we infringing any rights. And if somebody comes up to us and says, you're taking my idea, then we will stop doing it and we'll start another business. But until they come and until they ask, we will already earn some money. So this is a kind of a logic they pursue. And there's an alternative possibility of earning money without patenting. Maybe it's not relevant to IBM's business, but let's take Google for an example. They propose using their venue to make money using Google tools. And you can withdraw, and you can you cannot claim your own personal copyright, but you can still earn money. So there are opportunities to earn money without patenting. And to my mind, this patenting system today really feels great pressure. In other words, unless this system becomes less cumbersome, much more easier, just 10 or 20 years, believe me, and people will say we don't really need it. There are some more effective ways of earning money. Well, I don't know yet what kind of things are there. Sorry for speaking Russian. I hope that you understand my question. My question is, does IBM feel the pressure that the life is changing? And it's clear that this trend of earning money on IP right appeared just a couple of decades ago, but I believe it's only for the last 10 years it's becoming more serious. Does it really influence your business?
Thank you very much, Igor, for letting me to talk about this. First, I like to combine a few things to what I heard in the last hour a little bit. I will answer your question right away. Yes, we like this challenge, and we are an innovative company of 100 years, and we want to stay in business for 100 years. And I'm here to develop this business. And our business is resting on innovation. And innovation in the IT field is resting on data, and what to do with data is in two dimensions. So one of it, how fast can we process data? And the other one, what can we take out of data? I have a few slides which I will show in a moment, but I want to combine a few things because the title was a little bit intriguing me in the beginning. Who's the Titanic? What is thinking? Yeah? Will be the laws and the kind of regulations we put in place the reason that something in the IT industry will be thinking. Then I heard the initial discussions between Doug and Matthias, and I think in this environment IBM is not taking part. We are a business-to-business company. We are not a content provider through the internet, so we have the privilege not to comment on this, so thank you very much, but I'd like to mention this. So our business is with companies and our partners, and the partners that we have here, let me see if this moves, our strategy is here outlined on the left side. You see we make our markets by transforming the industry, and that means we have to anticipate where the industry will go and what our competitors will do. And if we provide technology, certainly we try to figure out what's innovative and we go to patent that. And if we are going to patent that, we have the first right of move already in ourselves. Because the moment we have an idea that's novel enough, and that's for everybody valid, not only for IBMers, it's everywhere. In that moment you have this idea, because that's kind of, you have two dimensions of ideas. One of it is a classical writing of a book or a writing of music or something like that. You go in the copyright environment, you have an unstructured environment, or we are in the technical environment where the idea is a novel idea and you patent it at the end. In that moment you have that, it's belonging to you and you have it, and the first right of move is the one who makes the first right business. In the IT, however, industry, it is today a very fast-moving industry. So we have these clones, we have these people that try to do business, like the patent or the copyright trolls in a different way, and we like to be fast still on what we are doing with our, let's say, patents. And for that purpose, we have established a system. I will talk about that system. The second point that was a little bit addressed by Victor here, look at point 2, we make enterprise IT in the area of cloud. That's a question we still cannot answer. There would be databases which are very solid, yeah, and protected, and then there is an environment that is approached to the internet through the cloud. You can get all the data, you can analyze for hours, and it gets the right information. Is somebody doing a patent violation or is somebody doing copyright infringements or whatever in order to figure out is there a case? And then the steps come, what do we do next? This cloud environment today is from a corporate perspective still a challenge, how we are going to manage that in future and how we protect ourselves. That's a question I may give later on to the panel here. How can we answer that? It's not completely clear. And then we have systems of engagement. That's how we are going to interact with each other. And for us, we are interconnecting with the business partners and with the companies. But this slide indicates in what kind of environment we are finding ourselves. You may know in the 60s we had back office computing, where everything was hardened and there were servers acting with clients in the 90s, the 80s and 90s, and there was a World Wide Web, which changed completely the complete infrastructure of the IT world. And today we have this big data environment, where the data that we are trying to analyze, whether it's a copyright data, written data, picture data, unstructured data, is exploding with more than 20,000 publications a day, and we have to figure out where is an idea that may infringe what we have tried to protect. To analyze this in the right speed is already kind of challenge. And to figure out what is relevant for us and in what way will we take this relevance into a kind of protection, law protection, or in a kind of business protection. And here it shows the cognitive systems that we put on top right now. A lot of that, what we are trying to do with programmable environment in the past, will be in future done by systems. So if you have Watson, maybe you know that, it's a kind of questioning, an algorithm that is embedded into computer systems that can go in a dialogue in order to reduce the kind of uncertainties at a higher confidence level to predict a potential answer. Is, for example, a patent or IP violation relevant or not? And that will be automated. And with this kind of tools, we try to help and protect ourselves. We also protect recently fraud violations. When somebody has a certain pattern how to approach your bank account through a system, or a kind of, let's say, ordering act through a system, this kind of procedures we have freshly patented in order to protect violations and fraud in banking environments. This is done with cognitive systems at the end. Now, there's a little bit too much here. We have hardware, software, service industries where we increase our IP portfolio, and here's the figures. I just go a little bit ahead, or it's a little bit small. But what you see in here on the right side, 6,809 patents were registered in the US last year. That is the 24th year in a row where we are leading compared to other industries. Second one in this row is Samsung. Around 2,000 patents we have registered outside the US. So if you add this together, around 9,000 patents per year we are registering. We have a portfolio of 60,000 patents active currently. Of that, 43,000 are active in the US, and 16,000 are active in Asia Pacific and EMEA. And around that, we analyze who is going to be a potential customer for our, let's say, intellectual property for innovations, approach them directly, and then we sell this IP via licenses. Or we look in the semiconductor field, for example, if it's a technology environment, we work on processor side, who is a real competitor and who would use what. And then we offer the remaining link also through license figures. And that is a kind of analyzing of potential clients and customers. That's a luxury we have, because in the business-to-business environment, we have the IP attorneys that will, most of the case, stay out of court. They will approach directly. And that's different from the patent or copyright trolls, where somebody writes on an uncertain environment, unbalanced information to an end user, consumer. And that guy has no other choice than going to a lawyer, and he cannot afford that, and he may end up, as Matthias has described, to pay a small sum to get out of this litigation. We have just, beginning of that year, we have litigated one of the biggest challenges we had recently. It was last year in November, a deal we did with Twitter. We found out that Twitter had, based on an infringement case, approached and violated 3 of our patents. We negotiated for 4 months, and in April this was settled. And it's a kind of side-by-side thing. Side-by-side means we show where a potential infringement is happening and why a certain customer, a business customer, is using patents, and in order to protect him, it's always a bilateral, a cross-patent licensing agreement we look at the end. So we ended up in that case, not only for the 3 patent clearance, or for the 3 patents clearance, we ended up for a cross-license of 900 patents with Twitter. And that protects Twitter at the end much better for any other litigation in future, and for us it was a business. But that was a kind of different approach. It was public to a certain point, but it was not in a court confrontation, not ending confrontation. So here you see a patent assignment activity. What you see currently already, we are approaching the numbers that we have last year, so we will continue on this. So I stop here. I'd like to stop here on this point. Just, I think the question was answered.
Okay, so I would like maybe to specify my question to you. So you are a huge company, so of course you are professionals in IP. You know how to protect yourself, and you file for many patents every year, but of course you need a huge amount of money to spend on this. You have to spend money on filing patents, you have to spend money on monitoring infringements, you have to spend money on your protection from patent trolls, attacks, and of course you say, oh, so we can adjust ourselves and we can be ready for future challenges and for all these changes in this rapidly changing world. But of course, it's good for a huge company. And but if we talk about startups, so you know, Skolkovo mostly supports startups, and really startups, from my point of view, form innovative ecosystem. And of course, for these people, you know, it's a very complicated world, and each year this world is becoming more and more complicated, and so it costs more and more money. You know, because I also know this example that Apple spent more money on protection IP than on research itself. So this brings me to some idea that something wrong in the patent system, because it's too complicated. So sometimes I have to spend much more money and much more hours to protect myself than to spend on the real activity, on innovation. So maybe could you comment on this? I know that it's, of course, you can say it's not my problem, but anyway, maybe.
No, it's our problem. It's I think the problem is always there when you have an idea, and when you have it, and you classify the idea and it's innovative enough, and you make a product out of that, and you have a patent at the end. So you have to watch in what field you are and in what industry you are. You mentioned you have your 5 cluster environment, yeah, and one of it is biomedical, and all of the clusters at the end of the day deal with data in order to be innovative. And I'm only representing the data environment, but we have clients in every field of those industries. If you look in pharmaceutical industry, you need 4 or 5 years to register a kind of drug. And in that case, it's very complicated, and the effort to register such a drug is in billions. And the patent protection around that is even more complicated than what we are doing in the IT field for software and other things. Yes, there is a kind of systematic protection needed, and it's also a differentiator in what field you are. And in this differentiation environment, it is also for startups a must to declare in the beginning what is an innovative idea in the right content. The question that I have more at the end is, how do we make sure that where it's declared, does it go in a repository somewhere? There was, and maybe Doug can answer this later, there was, I think in the 80s or 90s, in the Library of Congress, there was a lot of filing done, and later on it was abundant for copyright and other things. And you are right now addressing a similar point. So is that needed or not? I think the time of a central database is over, because the cloud and the environment that we have today is a little bit different. And if somebody published something, an idea, it's already associated with that person. And if you write a book in that moment, or a text, or a song, you're in the copyright environment automatically. And as a function from what country you are, you have the luxury of automatically be the owner of that. So that is what I like to give back. Yes, we are dealing with this in our way, where for technology a little bit different, because for technology we are following the market, and we have a limited environment for competitors. That makes it a little bit more transparent. For startups, it's totally different.
Kirill, what is a Enmar legal firm? I would like to ask, and whoever may answer, it was proposed to introduce the notion of an internet site within the state control project. As far as I will see, this definition has never been adopted. I wanted to find whether this decision would be made and whether it would be conducive to solution of some situations. I know, and maybe Victor will also speak about that. I can only say that there was no consensus about this applicability of this definition, about whether the definition was successful, and we decided to refuse from this definition. I think Vitaly Kalasin is in this room, and he is a proponent of this definition of an internet site. Maybe Vitaly will speak about it in more detail. Good afternoon, colleagues. Actually, our position was that we proposed a purely formal construction that could apply the same law to websites as applies to databases, so that we could decide how to regulate websites. IT industry thinks that the definition should match their specific needs. In my opinion, this is wrong, but since there is a contrast of opinions, we decided to refuse from this idea. Right now, the internet site is a complex work of art. Objectively, introducing new definitions is not always a panacea. We can see a tendency towards the appearance of subjects and objects in the internet that are kind of superstructures, and this process is not controllable. And actually, quite often we see contradictions between the old notions and the new notions. As for your questions, let's be pragmatic. Even if this definition arrives, it will not simplify life. It will not make life simpler. Everyone understands that a website consists of many elements which need to be differently regulated. Yes, maybe it will make your lives easier, but not more than that. And if we're talking about court disputes, the introduction of this definition will not simplify protection of rights. Nevertheless, they will try to find out who copied which part of the website and so on, and who made this interface. So the development of new regulations does not always makes life easier and clarifies the problems. Victor actually said, well, he actually stole it from me. In the judicial practice, we have a well-developed approach to website, and actually, if there is a definition like that, there is, paradoxically, there is more capability for misusing. We don't have a definition of a car or of a fridge, but that doesn't cause too many troubles with the judiciary. And Victor is right, I was not going to speak. I was actually going to say the same. There is no urgent need for that definition, and the court practice towards that remains more or less stable. Another problem that is more important, and it comes up to being a political problem. For the last 2 years, we've seen a clear tendency for competition between different branches of law and legislation. When the property law tries to operate notions that exist in the information law, and it would be very interesting collision, because everyone knows the problems related to know-how. When know-how was included into the individual rights law, that was a political decision. However, know-how is the most defenseless object of IP, which can disappear because of a leak of information. Of course, you can sue, and I haven't heard of such cases in Russia. So did that really make sense to introduce this notion into the individual rights law? In fact, what we are having, apart from those collision and competition between different branches of law, is a very important process. On the one hand, it's convergence. On the other hand, we have the public interests where the information and knowledge is important, and we also have the interest of traditional economy, and in particular the interests the IT industry is interested in having a monopoly. So the users want to get information free and easy. The startups want to use some of the new solutions, and the traditional economy, which has the money, operates in different categories. They try to protect their monopoly on IP, and this is competition, and this is a legal and a political problem, like in any other country of the world. And the internet is a kind of a litmus paper for us, whether we insist on the traditional monopoly or we decide that in the conditions when Russian Federation has fewer patents and fewer IP rights, we should provide a relief for those who want to use that information.
Before we open up the mic for another question, I would like to express my own opinion. I'm very surprised now, because starting from the 90s, Americans were really worried about their right holders. And they always kept saying, they were very outspoken, that in Russia the rights are being infringed, that American right holders are suffering because they cannot tap the Russian market. But the tendency of the last 2 years is surprising me even more than that, because the Western right holders are not saying anything. They're just keeping silent about the right infringement. And if they're not saying anything, it means that they are happy. It's the Russian right holders who are becoming more worried, and the Russian right holders are becoming even more and more loud. They believe that they're being stolen from. I think it's quite an unusual trend. Now, you can make your own you can explain it to yourself the way you like, but it still looks very funny. And as Victor has said, the number of patents in Russia is almost null, is almost insignificant, which really makes me sad. Because in Russia, foreign companies are doing more patents than our local ones, which is extremely sad to me. Yes, please. No mic. No mic. Yes. My question to the Russian experts. Let's come back to law number 187, if you please. Do you know that this law must be implemented? I'm not talking about the practice, I'm talking about your vision of the law. In such cases when there's nothing to do with Russia. Imagine we have a Hollywood movie that's been hosted on an American server, and can you use this law to go into court? And can we use the same type of laws on the blogs and social media? Because even IBM site and White House sites can be considered to be blogs by this new Russian legislation. I can express my own opinion, and I'm pretty sure I'll not be the only one who will talk to you now. The law is the right of the supreme class that's been multiplied into a status of law. And that's what Marx used to say. I think some of the parties who thought it would be quite beneficial to have such a law in place lobbied it through. This instrument seems to be not very efficient. As for its legal content, legal meaning, and the quality of legal work inside, it was always questionable. Or at least it always posed questions, sorry. I see smiles in the audience, it means that I am being understood. I think this law is a temporary solution, because it is clear that it doesn't meet the objective for which it was originally perceived. We hope that there will be other instruments, and we hope that these will not just be effective, but also sound. Thank you. I would like to continue, and I fully agree with Anton. Let me build up on this thought. From legal point of view, yes, this law allows you to persecute foreign sites and allows you to block foreign, or at least to persecute foreign content. However, the content will be traveling very fast across the foreign internet, and you cannot be able, and you won't be able to catch it. So you won't be able to achieve the objective of protection. There's another problem, the problem of the mechanism itself. Let's forget the foreign sites for a bit. The thing is that the mechanism, the law, is built on a simplified DMCA model, American model. And first, we're excluding a claim order, and we are going to court right away, and every stakeholder faces the fact that you have to delete something from your website or otherwise you will be blocked. Our American colleagues see blocking as the last resort. But again, blocking does not allow you to adequately respond to that. If somebody is not agreeing, they cannot counter-notice it, because in DSAM and in a number of other initiatives in the world, there are such mechanisms existing for counter-noticing. And there are some other technical moments. For example, the time frame for filing the claim, 15 days, is too long, because during this 15 days the site can stop existing, can cease to exist. And Anton was speaking about this, and many others mentioned it. This measure seems to be quite one-sided. And here we have a fight. All our legislation is like a litmus paper. We have a pendulum, right? Sometimes the right holders are winning, and other times it's the end users who are winning. Now we are seeing another swing of this pendulum towards the right holders. And I think this one-sided measure is there to serve the interests of a particular group of people, whether it serves the benefit of our economy and the internet itself. Unfortunately, I believe it's not been taken into account. I think the question is not about the foreign sites. I think the question is, can we really make a balanced procedure? Can we really ensure that there's a balanced procedure in place that takes into account interests of other stakeholders, the venues, the end users, and everybody else? Because this threat of blocking, well, imagine when you protect somebody's rights. You have some local counteractions, you can slap the face, and you can, take your leave, but you decide against slapping the face to drop an atomic bomb. Well, this is the kind of a problem that I see. Allow me to just comment it in 2 words. I think this law has a very long-fused bomb at the other end. I think the government has not yet realized, but it will soon realize another thing. It is clear that ISPs and hosting providers are not yet facing any monetary penalties or any monetary risks. And very soon they can be brought to justice without even being an infringer. And Russia is losing its market of hosting providers. The owners of ISPs, legal entities, technical databases, servers, data centers are moved out of Russia by these owners in order to minimize the risks. It's elementary math. 100 rubles is hosting per month, meaning you have 1,000 rubles from one client for a year. Imagine I come to a court, the court brings me back, gives me back 4,000 rubles. If you have 1,000 from a customer, the right holder asks 4,000 back, and very simple math actually shows to you that this ISP business in Russia is not feasible, is not economically viable. So basically the government is losing something it's been trying to achieve for a long, long time. A good, decent industry of ISP. This business is leaving Russia, and at some point in time the government will finally realize that cynically speaking, lost a controlled industry, and this controlled industry moved altogether to foreign jurisdictions, and trying to bring it back, well, as trying to bring back anything is quite a difficult task. As soon as this law was adopted, the Russian Association of Electronic Communication invited me to attend one of their meetings and conferences, and we have very good contacts with them. And they were very surprised when I said that there are some positive things about the law, and I will explain my position right now. For many years in a row, for 10 years, right holders and end users were arguing with each other. The end users were saying, let's introduce the following kind of rules in the internet. Well, basically, they were given references to the Digital Millennium Act. And the right holders were insisting on a more rigid model, but nothing was done. And we didn't have any norms and regulations in our legislation about the internet, which is also bad. So to my mind, and to my opinion, it is not always bad to have something done. Maybe we're just trying, we're making our first steps. Yes, we will pay the price, and probably there will be positive outcomes, but not in the nearest future. Well, the internet is still there, it is still working. The right holders will say we will earn a lot of money. I don't know whether they earned this money they wanted to. Let's live and see. The main objective of all this initiative was, well, let's make our problematic narrower. The main objective was to improve the returns of the Russian cinema industry, to increase the revenues of the Russian cinema industry. Have they been able to achieve this objective or not? Well, let's see in some time. And if there's no revenue as an outcome, probably the cinema industry will understand that something is missing. Otherwise, we need to turn off the internet completely or to do something else. Maybe to prohibit showing and screening movies in Russian cinemas. So maybe we will finally reach the next stage. So this law is to support the Russian cinema industry. And maybe, it doesn't have any direct relations to the internet whatsoever. So that's why I'm optimistic about the development of IP rights in Russia, because I don't view this law as the part of the IP system. This is the kind of a support for the cinema industry. Let me argue with you a little bit. If we live in the digital environment, in the digital community, we have to realize that what I was talking about, the things too abstract. You see, the website can move. A website can move from one hosting to the other. You have different software to build your websites. New cloud computing technologies are appearing. New realities are there. And if we are going to use this try and test methods, by trials and errors, I'm pretty sure we're never gonna stop. First we try, we probed with a stick, we saw that it's not working, we go back and start again. But that works normally in a normal kind of an environment, when the environment is not changing too fast. But now the changes are very rapid. And if we follow this way, we will create a slope, and following this slope, all the internet will go. Imagine they pass this law, everybody will just say we will not going to come back, we're going to try some other things, and it will follow like a snowball. Now the government is trying to probe, is trying to forge its new idea of regulating the internet. And objectively, the Russian Federation, as the majority of the country in the world, is facing the same kind of problem. It is extremely important to shift focuses. First, we need to understand what's more important and what's more feasible for the government. And we really must understand what kind of institutes and what kind of definitions we have and how it should work. And then we need to patch what's not working and close all the gaps. But we are going in a different direction and in a different way. First, we're closing the gaps and we are patching up what's broken. And only after that we start thinking what kind of overall effect it might have. Unfortunately, we can't really make any predictions or any solid calculations because the decision makers, they were not proven, they were not convinced by anyone what kind of consequences this new law will entail. Because when you prove your case, when you prove your point, when you provide the necessary calculations, the solid outcomes, then you can make yourself heard. And this is why we ended up in a situation like this. Well, we'll live and see. Are there any other questions in the audience? Maybe Matthias or Douglas. Oh, Matthias wanted to add something. But my question was like this. Matthias, Douglas, you all became witnesses of a certain discussion today. Maybe you become more familiar with the Russian specifics in this sphere, in this anti-piracy fight, and you listened about some other things. For me, it's always interesting to know, we, as Russia, how do we look as opposed to Germany and the US? Do you have the same kind of debates or arguments? Are we lagging behind? Are we trying to reinvent the wheel? Or is it something special and something unique about Russia that you haven't heard anywhere else? And this is just the argument we have here.
Yeah, I'd like to take the opportunity and make one remark by giving you an example again from Germany, but then asking you a question considering that exact situation that you are debating right now. And I find very interesting, although of course I don't understand the details because I don't speak Russian and didn't read the law, but what happened in Germany was over the last 4 years there was a law that was proposed by the German publishing industry, and that proposed to create a new intellectual property right, a neighboring right to copyright, and it was supposed, or it is supposed to protect, if you want to call it that, to protect the publisher's content from being used on the internet, especially by search engines, meaning that it gives publishers the exclusive right to snippets of their content. Snippets meaning, for example, the stuff that is being displayed on a search engine's result page, be it Google or Yandex or whatever it is. You usually have a title, you have the URL, and you have 3 lines of content, usually, what's surrounding the search keywords that you typed in. Now, this is supposed to be a snippet. In this snippet, there are no rights to that in Germany. Under German copyright law, this is not a work, this is not a copyrightable work. There is no, of course you have a text, I'm not talking about the text that's behind it, let's say a news item that was published by a news publisher, but I'm just talking about these 4 lines of text that's displayed on the search page. Now, the publishers succeeded in a political fight. There was intense lobbying going on for 4 years, and they were able to convince the government that it's a good law. The government was the only one they were able to convince, because you will not find one expert on either IP, economics or competition law in Germany who will say that this is a good law. We don't even know what it means right now, because it's so fuzzy that it'll be interpreted and reinterpreted by the courts for the next, 10 years or so. Just this week, the Collection Society that the publishers commissioned with exercising this neighboring right sued Google because they were not willing to make a deal with them, because they said, no, we're not going to pay. We don't really know. Well, we are arguing, we're claiming that we don't have to pay. So this basically was the start of years and years of litigation. Now, why am I giving you that story or that example? Because what is lacking, in my opinion, and this is a general problem, and that's why I think it is not a Russian problem, it is not a German problem, it is not a United States problem, it's a general problem in this whole debate about IT, that it's rather not fact-based. My question is, explicitly, is there any idea or is there any proposal to have studies being done to find out what effects the law will have and whether they are detrimental or positive when it comes to the effect that is being proposed? Is anything like that set up? Will it being, will there be research to find out whether this is a good law or a bad law? If there are studies like that, will they have any effect? Will the law be rethought and people will argue that, it was probably something that was not really fostering innovation, but it was harming innovation, which is something that many people claim about this new neighboring law in Germany. In Germany, I can tell you that this is not being done, at least not on a large scale, and that the economic effects of lawmaking are rather in the dark and not being discussed. I know that there's a tradition of law and economics, but it seems to me that this is still rather, even that debate, resting on theoretical arguments or even dogma and ideology, and not so much on empirical facts. And I think this is what unites all the rule-making and governance in the different countries, be it Russia or the United States or Germany or the EU.
I think there were quite many research on the effects that could happen after the certain law. But all this research are based on some assumptions, and they cannot be proved. So, for example, some people say if there is no possibility to download video from internet, then all these people, 70% of the people, will go to cinema and will pay for tickets. And other research say no, not 70, 10. And so that is the problem.
Just to follow up, I meant after the fact. Now you have the law.
Yeah.
Now you have the chance to find out whether anything changes, right? So is that being done, and is the law being re-evaluated probably in a year or two, or probably 3 years or something like that? Is that a process that is set up? Or is that just, we have a law and it's there and now no one cares anymore?
There's no right holders say, oh, it's okay, it works, but we need something more.
Well, the thing that sounds so familiar in this discussion, intramural discussion in Russia, is that in the US, it was the cinema industry, motion picture industry, and the music publishers who were fueling the initiative for legislation. They looked for technical fixes because they couldn't get legislation. I mean, something they could build into the software. Without real success. And so, pardon me, it's become an accepted proposition that, and I think there is empirical support for it, that the motion picture industry was losing X billions of dollars, I don't know what it was, to piracy before it was primarily on the web, when it was still digital, on disk. And that the internet has only compounded that, but it's almost impossible once you have on the internet to gather the kind of solid information about that. That's also, I think, widely accepted in the U.S. among the few people who follow this, that IBM notwithstanding, the U.S. Patent and Trademark Office issues too many patents on software. That it's been quite profligate in issuing patents. The Court of Appeals that is specialized to hear intellectual property cases never saw any intellectual property it didn't like, apparently, and so it's had very expansive interpretations. It's been reversed several times by the Supreme Court. And now, in the most recent instance of a big opinion coming out of that court, there was no majority opinion, but it casts some real doubt as to whether algorithms will continue to be patentable material, and also business methods, I think, are in question. So there's been a swing, a pendulum swing towards patenting very generously cutting back now, I think, a bit from the court. The American Invents Act has been in effect for about 3 years, and because there's so many software patents out there of unknown validity, and testing the validity of a patent is so expensive and time-consuming, the American Invents Act created a post-review procedure in which the patent could be challenged in front of the Patent and Trademark Office before going to court. And the significance of that is that a patent is issued ex parte. It's not an adversary procedure. Right? Somebody applies for a patent. The examiners determine that it's novel and is not obvious. They issue the patent. And only after the fact, the dispute arises. So a procedure was put into the law by which the objecting party could go back to the patent office and say why the patent should be withdrawn. But as I understand it, the procedure is not being used very widely. It doesn't really solve the problem as it's been perceived.
So, Doug, you talk about CBM, right, don't you?
I'm sorry?
You talk about CBM, so covered.
I'm not talking about IBM. That's
No,
for sure.
CBM.
CBM.
You talk about CBM.
You talk about the case name?
No,
I'm not sure what you
no. This covered business method. In order to figure out
business,
what,
yes,
that's what you talk
business
about.
method, right.
And you know the industry has a different perspective on this. You know that.
I'm sure.
Yes. Yes.
And I don't think that IBM has been implicated in applying for frivolous patents.
No, not, but we have taken positions here, but I don't want to take position. I just want to, because you mentioned this, I have to
Yes, go ahead.
Look a little bit in the past. Yes, there is this Titanic and all of that stuff is still thinking. Yes, is the systems that we have today, are they outdated or not? Do they need change? Yes, they need to a certain point to change. And one thing where you asked the question, is Russia in a certain point behind? Yes, Russia is behind in filing of patents, and that has to be changed dramatically. Because if you compare the numbers of inhabitants, researchers, scientists, Germany alone makes between 30 and 35,000 patents a year. And what does Russia do? Put this, so there is a gap that has to be changed. And as long as somebody believes this is not protected, there is no motivation. And within the last 5 to 6 years in Russia, there is a stream where the belief is getting generated. There is protection, and that has to be more stimulated. So there's one side. The other, I look a little bit back because I can talk about IBM. Before the 80s, IBM never filed software patents. We gave even the software away for free. We sold hardware systems because we're a big player. We're selling systems, including the software and the operating systems, and we give them for free. Somebody later could deinstall and separate the two things and could reuse it, but that was not where we had the highest margin. That was changed in the 90s. And in the charts and slides I showed, around 30–35% today is software-driven, software patents. But in a process, somehow always connected in a kind of functional method. And that is where we think, yes, the CBM topic has to be analyzed for a quality perspective to a certain point.
But to give you the rest of this, the example of just how far out the Federal Circuit Court of Appeals had been in the Patent and Trademark Office, the case that went, I think most recently to the Supreme Court, is one in which a patent had been granted on software for the purpose of facilitating transactions by holding proceeds in escrow while goods or other value was delivered and then releasing it. Well, this is, the court pointed out, this is the way the law of merchants has operated for 400 years, at least since Venice was a major commercial power, and perhaps well before that as well. And to put that into a digital form and then say it's patentable simply because it's a digital form of something that's been done forever was really folly on the part of the Trademark Office, but it was rather typical, I'm told.
One comment to what you said, Judge Ginsburg, because you certainly know the story about Jack Valenti, at the time spokesperson of the not the recording, the Motion Picture Association of America, in a hearing saying that when they were debating the Sony Betamax case, meaning that Sony was sued for I think it was selling the VCR in the United States, and he said the video recorder is for the music, for the film, for the motion picture industry, what the Boston Strangler is for the woman home alone, right? Referring to some serial murder who killed women in Boston, right? Now, that is a very, very vivid case of an industry having to be forced to innovate. Because the Supreme Court decided, no, the VCR is not copyright infringement, and 10, 15 years later, the motion picture industry was making billions and billions and billions of dollars from selling tapes and discs and so on. Now, if I think it was Anton who made the remark in the beginning, I think we need to take into account the, an economic welfare model here when we are talking about protection on the one hand and a opportunity to innovate on the other hand. And I have a couple of examples to illustrate that. If you remember the Napster and Grokster cases in the United States, that was basically the outcome was that file sharing was almost outlawed, right? At the same time, these companies or models or whatever you want to call them. Both of them were companies, otherwise they couldn't have been sued, but of course they are networks that are decentralized and they're not really companies. But this technology and this technological innovation, I mean, there's no doubt that it's a technological innovation, also meant that Apple, in the end, was able to license content from the major labels to sell it via iTunes. Otherwise, there would not have been the pressure to do that, right? So this changed the entire music market, and now every year we read the press releases from the music industry bragging about the more digital items they sold last year than they sold the year before, right? We have two other examples that are really interesting in that respect. One is Spotify and one is Script-D, or however you pronounce that. I'm not really certain about that. Now, Spotify, I don't know whether you're familiar with that because it hasn't been introduced to the Russian market, but it's a streaming music platform that you can subscribe to, and that doesn't only give you a huge catalog of music, but at the same time it has artificial intelligence suggesting what music you like based on the music that you're already listening to or that you listened to in the past. So it's really, really popular. It's not from the United States, it's from Sweden, but they are now active in many Western European countries, in the United States, and so on and so forth. They started out basically as a pirate site, right? They allowed people to upload music. Now, do I think that's a good idea? No, I'm not going to say it's a good idea, but what happened is when they became big, they had the market power to go to the, first of all, that's the more important case here, I think, or a more important aspect of it is, they found out what users wanted, right? They're enormously popular. They found out what users wanted, so they established a market, and then they were able to license their music with the music industry, and now they're legalized. They're a legal offering, in all countries. Same thing happened with Script-D, where people were allowed to upload documents, PDFs, and so on and so forth. Many people started to upload books that they scanned themselves, or e-books. Copyright infringement. They didn't have the right to make them available online, right? Same thing happened. People found out, or Script-D found out, and it's just one of the players there, found out what people wanted, what business model was working. In the end, they licensed all the stuff from the industry, and now they're selling a flat rate for reading. You can pay $8.99 or something like that per month, and then you can go and read everything that they have on the site. So this is what I'm referring to when I say we need to look at an economic welfare model of all this and find out what is the correct level of protection and what do we still need not to protect in order to be in order to enable people to innovate. And I'm not saying that I have the answer, unfortunately not, but I think it's not looked at closely enough in all these debates about what harm is being done by piracy.
The rejection of the motion picture industry's view about Betamax and the Supreme Court saying it's not copyright infringement, and the industry later profiting from the sale of discs, I think it was, right? Videotapes, right. Tapes was what Betamax played. The correct solution to the Betamax problem was not the one that the court devised. The court had no power to do this. The correct solution was a tax on blank tape, which would go into the Copyright Royalty Tribunal and be distributed pro rata based on sampling, just as is done with music on the radio and in live performance of music.
Was that in Germany, actually?
That is what was the tax on tape. Yeah, well, that was the economically correct solution. So what the Supreme Court said in Betamax was, look, you released this program for people to watch over the air. All they're doing with Betamax is shifting the time in which they watch it, at least 70%. The other 30% were editing out commercials and so on, which was not an inconsiderable thing, but they brushed that away. Now, iTunes, you say, well, people are bragging about how many downloads they have. This has very much affected the music industry, and the labels have adapted to some degree, but the performers are very much dislocated by this, and bands now, popular bands now, must make their major revenue, particularly in the early years, from live performances and the sale of merchandise. So they're out there selling T-shirts at their performances instead of records because they've lost control over that. It's hard to think that is an advance.
It's too late to answer to that. We only have 3 minutes.
Да, наше время подходит к концу.
Yes, our time is coming to its end. I thank all the participants for a very interesting discussion, and I hope that those who participated in the roundtable and those who listened learned something new and maybe will have a different view of the problems that we will discuss today. And I hope that this forum will be a site where we will again discuss the IP issues. Thank you. And don't forget, probably, this roundtable was organized by Skolkovo. You have booklets about Skolkovo here. So we are inviting you to our place. The Innovation Center is being built, and every day it becomes more and more interesting. Thank you.